Check out carmarshal.com. The link is in the description. They help support us.
Item 6, ordinance number 2014-30. City Clerk, please read by title only.
An ordinance of the City of Northport, Florida, amending Part 2, Chapter 2, Article IX, Code Enforcement of the City Code, providing for conflicts, providing for severability, and providing an effective date.
Thank you. City Manager.
City Attorney.
Or Attorney for the City?
Careful. Commissioners, this is the second reading of the ordinance we had back in July, which converts the current board format for code enforcement hearings to a special magistrate. This carries out the direction of the commission received in a workshop in April of this year. This will take effect October 1st, and if you have any questions, but it's second reading.
Any questions from Commission? Commissioner Yates.
Yes, I have lots of concerns, but I'm going to focus on my question here, and I have information handed out to everybody, and this is from the Attorney General's office in regards to Article 2, Section 5 of the Florida Constitution and dual office holding. So by approving this special magistrate to replace the code enforcement, it would actually implement the motion that was made at the previous meeting, which approved the continuance of the ordinance, as well as the appointment of Mr. Robinson as the special magistrate. So I bring your attention to in here on page number 7. And this talks about the fact that when you have different offices, you cannot have the same person appointed.
Just excuse me for 1 minute, Commissioner Yates. I believe this ordinance isn't about who's going to be the magistrate. This sets up the magistrate. That's all this ordinance is here. I hear what you're discussing. That's a whole different subject, but I believe as I read the ordinance, it's only to set up the magistrate instead of the board.
I understand.
That's what we should be discussing here. I understand this. This is a whole other situation.
Well, I understand that, Mayor, and it presents an issue, as I said, because at the first reading, it was a continuance of the ordinance, but also the appointment of Mr. Robinson for a 4-year term as the special magistrate. So if I were to support this motion for setting up a special magistrate, it would implement and create that position which has already been filled by the previous motion. This is why this is a question, is because if I vote on this, it would set up that situation of dual office holding by one individual being appointed already as the special magistrate. So,
Attorney for the city, when we set the ordinance in the first reading,
you're exactly right, Mayor. You don't need to appoint somebody twice. If you were going to go through that process, you certainly wouldn't do it twice. This is simply the second reading of the ordinance, which switches it to from the board to the special magistrate process. It has nothing to do with the prior commission's consideration and discussion at the last meeting, so it does not. I don't want to get into that issue up here, to be honest with you, because I couldn't disagree more with the learned opinion of Commissioner Yates. But at this point in time, this ordinance you have in front of you has nothing to do with who's going to be the special magistrate. It's just whether you're going to do it or not. Either are or you aren't.
That's what I thought. As I read the ordinance, I didn't see what you're talking about in the ordinance. So.
Yeah, I know that, and that's why I raised the issue at the first reading, because how do you appoint somebody, which it was done. I can read the motion that was made at that meeting. It appointed Mr. Robinson as the special magistrate, which the position wasn't created yet because it was only first reading.
Right.
So approving this ordinance today will create that position, which then Mr. Robinson is the special magistrate. Unless somebody can tell me that that appointment at the last meeting didn't count, I mean...
No, I can't
okay.
tell you that.
So if my question is, if the commission approves this ordinance and a special magistrate position is created, Mr. Robinson, are you then serving as the special magistrate?
For the vote and consideration that occurred in July, yes.
Exactly, and that's my point.
But I'm not agreeing with your position that by voting yes today, you're voting to appoint me.
I didn't say that.
I don't think that's.
I didn't say that.
What? Oh, I'm sorry, I misunderstood you. I
It's,
don't
or
mean
you've
to
already
misquote
been
you.
appointed. It
Assuming that
implements.
the commission makes
If we make this-
assuming the commission makes the switch from one to the other, if that's the direction of the commission, that was the will of the majority of the commission in July.
Okay.
Correct. All right. So now that you understand what I'm talking about, so the concern that I have with this is that, Mr. Robinson, you had been appointed as the zoning hearing officer, which is an office. And it's even in an office based on what I just passed out.
But Commissioner Yates, that's what I'm saying, that is a completely different topic than we need to either approve or disapprove of this ordinance. And this ordinance has nothing to do with Mr. Robinson as the magistrate or not the magistrate. Has absolutely nothing to do with it. So if you would, please, just stay on this. Let's get this through. That was already passed.
Thank you. Yes, that's exactly what I'm saying.
That was passed if this is passed.
Correct. And I need, depending on what the answers I get, which I'm trying to ask my questions, will determine whether or not I can support passing and voting in favor of creating the special magistrate. So
I think if you vote in favor of the concept of a special magistrate today, you're not voting in support of me being the special magistrate. You voted against that the last time. So if you vote in favor of this today, that happened back in July. I don't see how you are voting, depending on what the motion is today. I haven't heard the motion yet. But if it's just a motion to approve the ordinance, then you're just approving the ordinance. The appointment already occurred back in July. So I don't believe a yes vote for passage is a affirmation or is contrary to your previous vote.
okay, you might be answering somebody else's question, but so you will be serving as a special magistrate if this ordinance passes. So my question is, while you were appointed as the zoning hearing officer,
Commissioner Yates, there again, I hate
Mayor,
to- I hate
please
to
let
keep-
me ask my question.
I hate to keep interrupting, but you're asking a question that has absolutely nothing to do with this ordinance. Let's get through this ordinance. If you want to discuss that at another time, then fine. But I think it's after the fact already is what you're discussing. So if you have questions about this ordinance, please ask them. But let's leave who the magistrate is out of it, please.
Okay. Well, as I was getting to, on page 7, it talks about the code enforcement officer being in office. A special magistrate would be in office. So if the ordinance passes, then the appointment is made as special magistrate, and we would have the same individual serving in the capacity of the special magistrate that would be approved today, that position,
And that was answered.
as well as serving as a zoning hearing officer. And so my question is to the attorney, in his opinion, can we actually have that situation where the same individual serves as two officers based on the dual office? Because depending on your answer, is like I said, depending on whether or not we should or shouldn't move forward in passing this.
City attorney, or attorney for the city, I'm going to ask you not to answer that.
Oh my
That's a different question. If that's the only question you have, think about that. In the meantime, Commissioner Cook.
Actually, that was the question I was going to ask to the city attorney. I was going to clarify because to me this ordinance is simply passing an ordinance removing the Code Enforcement Advisory Board and putting it into a special magistrate's hands. We were not appointing anybody. That's my understanding
That's
of
correct.
the ordinance.
That's correct.
Secondarily, I'm wondering where this document came from, dual office holding that the city clerk just handed out. Does anybody know where this document came from?
You may not have heard, but I did disclose that I was handing that out for information that I was going to be
I
speaking
guess I'm
to.
curious as to why it wasn't put into the backup document, since we all know that transparency is first and foremost. Why weren't the people given a chance to look at this document as backup documents? But that's okay. You don't need to answer my question. It was a question for the clerk, but thank you.
And this was not my item on the agenda. So.
Point of order.
Point of order.
Commissioner
What is
Yates, go ahead.
Okay.
Please ask your questions about the ordinance. That's all.
I am, and
that's all I'm asking.
it's very clear to me, and I'm sure to the public, what's going on here. But you know, my question is really of us passing this.
What's that
whether or
mean
not,
to the public?
Because I'm not. You're saying don't answer my question, Mayor.
No, I'm not.
It's a
I'm
valid-
saying
valid
ask your
question.
questions about the ordinance that's in front of us.
And this ordinance in front of us creates a special magistrate position.
Yes,
Correct?
it does. Yes, it does. That's all it does.
Correct. And without passing this today, we would not have a special magistrate yet. Even though one was appointed, we wouldn't have it yet.
If we don't pass this today, we do not have a special magistrate, period.
Correct.
Period.
So there would be no concern of mine then, if we don't pass this today, I would not be concerned that there is a question of being unconstitutional in appointing the same individual to two offices when it's right in front of us. We cannot do that.
That's the same question. See,
So-
that's where I understand where you're going, Commissioner Yates. I do. I just disagree that we need to get on this, and now I'm going to ask for a motion, please.
We got public comment.
Do we have public comment?
Yes, we do.
Thank you. Connie Bruni?
Ladies and gentlemen, my name is Connie Bruni, Northport, Florida. I oppose this ordinance in its current form. The city, at every turn, seems to be eliminating or discouraging public involvement in the running of the city's business. This is not a good trend. More importantly, the act of the sitting city attorney giving advice to appoint himself to a paying position that did not even exist, and the lack of a proper procurement process on its face appears to be an obvious conflict of interest, at the very least, and possibly a violation of Florida's state statutes. To me, it's downright laughable. When you were laughing earlier, I'd be laughing at that. Since the citizen boards exist, I do not believe there was any urgency to appoint the soon-to-be, formerly city attorney, to a non-existent position. I don't get it. In fact, the city commission just hired an in-house city attorney. Wouldn't it have made more sense to allow that individual to weigh in on this idea and its implementation? Where was the urgency? Doing so would have allowed the existing boards to meet and hear issues as needed, and then go through a proper bidding process. That has all been eliminated. Doesn't make sense to me. Instead, the process used here smacks of backroom self-dealing. I'm calling it shenanigans. If this ordinance goes forward with the appointments as opposed, I retain my right as a resident of the state of Florida to file a formal complaint with the State Attorney General's Office, the American Bar Association, and any other appropriate organization about these abuses. Each of you are the elected leaders of this city. You are responsible to the public and to the law for each and every vote you make.
Thank you. Sherry Smart?
Hi, Sherry Smart, Northport, Florida. Commissioners, I have no feeling one way or the other, either in opposition or in favor of Agenda Item 6. My request, as stated in the City Charter, page 5, line 3, responsive to the electorate, that the Supremacy Clause be added to this ordinance. Should you not have that language, I provided a copy to the city clerk. As a member of the electorate, and you and the commissioners, according to the city charter, are responsive to me. The people demand that the supremacy clause be a part of this ordinance. As all of you have pledged your oath of office, this request is in accordance with your oath. Thank you.
Thank you. Mr. Yates.
Yes, I had another question in regards to the language in the ordinance as it refers to, on page 2, the definition of prosecutor. Means a person or persons designated by the city manager to present cases. The charter, our city charter, section 14.05b, actually says that the city attorney shall prosecute cases before the Code Enforcement Board. This ordinance does state within it that the special magistrate shall mean the same in reference to the Code Enforcement Board. So it just presents an issue that it appears by the charter that it would not be the city manager that makes a determination on the prosecution. It's a charge and a duty of the city attorney. So that language is on page 2, and it is also on another page within it, and I do think that it needs to be clarified. Legal counsel, page 5, you'll see the same reference. The city attorney, when requested by the city manager, however, the charter says the city attorney shall. So that's
Question to,
yeah, city attorney, I get, or attorney for the city.
Commissioner, this reflects the reality of the way things have been done here since before I arrived, which is that that I have, or nobody from my office, and I don't think my predecessor ever acted as the prosecutor before the Code Enforcement Board. That role is served by the staff who serve through the Neighborhood Development Services Department and whatever they're called within that department that deals with code enforcement. So just as the city attorney does not act to defend all lawsuits filed against the city, which is the preceding one above that, I'm sorry, the one below that, it's just the way the city has operated. So if there's going to be a direction to there would have to, I think at that point, be a change in the way the city and the staff and the administration present these cases to the Code Enforcement Board. In other words, the city attorney would have to do it if we're going to follow the specific language of the charter, which to my knowledge, at least during my time, we haven't. Now, the city attorney is available to do that, but it's always been the responsibility of usually they have a name, that's the people that write the what? Thank you, the property standards folks. And this is just my observations, and having never been asked in 14 years to serve as a prosecutor or be told that was something we had to do routinely. Now, going forward with the new city attorney, maybe you want to do this differently. But this ordinance simply reflects the reality of the way things are presently, which is either the city attorney can prosecute or someone designated by the city manager through the director, which is in fact the property standards person who actually usually is the one that writes the complaint. They're the ones that are sort of the investigator for the violation. They're the ones that act in that capacity. But if you want to direct a change in regards to the language within the charter, that's fine. We can certainly revise it. But this ordinance reflects the reality of the way the city operates.
Okay. And so I guess my question and concern is that the charter is the guiding document for the city. It's almost like the city's constitution. And so I don't think that we can pass laws and ordinances that actually supersede the charter. So where the charter says he shall act as prosecuting attorney before the Code Enforcement Board, whether or not we've done it that way or haven't done it that way is irrelevant. I can't change the past. But in this new ordinance, it certainly seems problematic to me if we're not going to follow the charter. Now, we could change the charter by putting a referendum on the ballot. The fact of the litigation, well, that specifically says in there, except where the city's defense is provided by contract. However, the other part doesn't when it comes to prosecuting the Code Enforcement Board. So you're saying that we can implement an ordinance and implement a law that does not conform to the charter?
I'm saying that you have lawsuits right now that are filed against the city that are not defended.
I'm not talking about lawsuits. I'm talking about the Code
I'm talking
Enforcement.
about references to where the letter of the charter, the spirit of the charter is followed, but the letter of the charter is not, and that's an example. We routinely do not respond to all foreclosure complaints in which the city is named a party, in which you have a nominal lien. We just don't. Although the way the charter is written, you can make an argument that the city has an obligation, the city attorney does, to defend, but that was the instruction we received from the commission. Don't do that. So we haven't done that. I'm just telling you the reality of the way the city operates. So if you want to do it differently than the way they're doing it now, or the way they've done it at least during the entire time I've been here, that's entirely up to you. You've given Mr. Moriarty a new job, but that's fine. We can change this language to state very specifically that the only person that can present and prosecute before a code enforcement board or anyone is the city attorney and not staff.
But you don't have an issue with the language in the ordinance based on what the charter says?
Not the way we've written it. I think as long as you have a city attorney, Mr. Moriarty, now I understand he has a lot of experience in the code enforcement area. He may very well get here and converse with the city manager, and they may come to the conclusion that you do move into a true prosecutorial role for the city attorney. But then staff steps out of that role, your property standards officers who have traditionally undertaken that role during at least the last 14 years that I'm aware of. But I don't have a specific issue with it as long as the city attorney is involved with that decision. But again, you can certainly change the ordinance the way it's written now and make him the sole prosecutor to the exclusion of anyone else.
Okay, the other question I have is on page 5, legal counsel. The paragraph B is stricken, and it says, in no case shall such appointed attorney represent the municipality or present cases before the Code Enforcement Board, thereby eliminating possibilities of conflict of interest. In number A, it's really not including similar language in regards. It's page 5.
I apologize.
Page 5.
I see 2-507A. Where were you reading before that?
B.
B?
Mm-hmm.
B is very long. Where in there?
It's stricken in there where it's talking about, in other words, you can't have the same attorney appointed to represent the municipality that would actually present cases before the board. What I'm saying is in A, there's not similar language that would protect a situation where you wouldn't have the attorney representing the city acting as counsel or being appointed as a special magistrate.
I apologize. Again, you're looking at 2-507B.
Page 5, section 2-506, legal counsel.
506.
So what I'm saying is with B stricken,
This is the attorney that actually sits with the Code Enforcement Board.
right?
They don't, although they're under contract with the city, they don't really represent the city. They don't prosecute before the board. They actually provide legal advice to the Code Enforcement Board. There was a similar attorney appointed when the CLAB existed, Contractors Licensing and Advisory Board. Those are the only two boards that I'm aware of in the city which had separate legal counsel, because the city attorney could not sit in that role.
Yeah, I get that. I understand that. What I'm saying is now going to a special magistrate situation, there's not language that I see in here that would preclude the city attorney, number one, being appointed as the special magistrate, or any attorney representing the city being appointed as a special magistrate. Similar language was actually put in the zoning hearing officer, that no zoning hearing officer may be appointed that would be serving another office or another position or representing the city. I don't see language in this ordinance that actually retains those protections.
Yeah, I really, without
Unless
having
you can
the
point it
ZBA
out
one
to
in
me.
front of me, I mean, I mean, this really just addresses that the city attorney is not going to act as the general counsel to the special magistrate, and that would be consistent with the way it is now with the Code Enforcement Board. The city attorney does not act as a representative to the Code Enforcement Board. So in this part of this ordinance, I think all it does is indicate that the city attorney is not going to act as counsel for the special magistrate. That's all this does.
Right.
So,
But is there anything in this ordinance that precludes an attorney representing the city from serving as a special magistrate? Because I didn't see any language in there.
and I'm not understanding the question. Are we talking about the city attorney? Are we talking about bond counsel? What are we talking about? I really don't understand the question.
What I'm talking about, and probably maybe you can relate to, you know, as far as due process, the same attorney representing the city on city affairs, city issues, could not be appointed as a special magistrate.
No.
I don't see language in here that makes that clear. Although it is very clear in the zoning hearing officer one that was written and was passed, it's not in this one.
Yeah, I'm not going to be able to recall the verbatim out of the zoning one. I don't recall that being in the zoning one. I recall similar language in there that the city attorney, whoever that is, does not act as the counsel to the zoning officer. Mm-hmm. So to me, they're consistent with one another in that regard. So I think that's the best answer I can give you.
Yeah, and the zoning hearing officer, it was, since you couldn't recall it says may not be a, you couldn't appoint somebody that was a city employee, officer, board, or committee member, and language in there as well that could not represent the city. So I just found that was missing in this ordinance. And that's it.
That's it. Mr. Cook.
Okay, I only have one question for the city attorney. The ordinance as it is written, is it legal?
Yeah, I think we covered that originally back in April when this presentation was made to you by staff, not me, by the way, that there are certainly an equal number of jurisdictions in the state that utilize the special magistrate for code enforcement matters, as do code that actually use boards, and that is specifically allowed by statute. So the conversion to a special magistrate has been authorized for many, many, many years by the Florida legislature.
Okay, I'm ready for a motion. Okay.
Okay.
Move to approve ordinance number 2014-30.
Second. I have a motion made by Commissioner Cook, seconded by Commissioner Jones to approve ordinance number 2014-30. Any discussion?
None.
Seconder. Commissioner Yates.
Yes, I really believe that we should continue this ordinance until the new attorney comes on board and reviews it. There are some concerns with the language, protections not in there that I believe should be in there. I cannot support this, and for the record, I'm going to say again, by approving this ordinance, the special magistrate will come into play And this commission majority has appointed an individual that will be serving 2 quasi-judicial positions, which is clearly unconstitutional. And I cannot support moving forward with this based on that, primarily that reason, as well as the process and how this was done. We needed to have some other options. We were told we would have options of attorneys. We had a code enforcement attorney serving since 2006 at $175 an hour. Based on the appointment that was made at first reading, we will now be paying $275 an hour. And as well, I'm very concerned of the potential due process challenges on zoning and code enforcement matters, because we do have the same attorney, should this go through, representing the city on all legal matters as directed by our city attorney, new in-house city attorney, as well as serving as a zoning hearing master, zoning hearing officer, as well as special master. And I do think that this sets up and creates challenges that may come forward for lack of a due process. Also, the other issue that I want to state is I've pointed out what our charter reads. Our charter is our overriding rules of this community. And to have something in the language of an ordinance that conflicts with that, I cannot knowingly support something like that. So those are the issues for the record.
Okay. Call for the vote. And that's approved 4-1 with Commissioner Yates dissenting for her stated reasons. Is everybody okay, or do we need a little break? Okay, we need a little break. We'll take 15 minutes.
County, this is Charlotte County COPWATCH, and I wanted to explain what fair use is. You can use pieces of news articles if you're doing it for news reporting, you have commentary, and you're doing it for education purposes. So that's what fair use is, as you can see right here. Another reason why I wanted to make this video is to let you know I have just joined with Patreon. A nice thing with Patreon, I make no money on YouTube. They took the money away years ago, and so this is another way to give, and it's a nice thing too, because you can give monthly. You can give $1, $5, $10, whatever. I do 4 to 5 hours a day on trying to wake the sheep up on how corrupt it is and different ways that you can fight the corruption. So Patreon is a way that you can do it, and then of course the old way is still there. Donate to Sheriff County COPWATCH with PayPal or credit card. So keep that in mind. 4 to 5 hours a day. I make no money, but the corruption happened to me, and I'm sick of it. So I'm trying to wake people up. But my wife would love it if some, if we could get some help out there. There's 47,000 subscribers. Just think if each one of you subscribers just gave a, let's say, actually, yes, $1 a month. 47,000 subscribers gave $1 a month. That would be awesome. That's not going to happen. But anyways, that would be great if it did happen. But do the math in your head. Just think about it. Like I said, 4 to 5 hours a day. I get no money from YouTube. YouTube has gone nuts. You can't do anything anymore. They're taking the money away everywhere. So these are a couple different ways that you can still help out with all this time that I put in. And as you know, I'm in a special situation where, at least I can do it. 4 to 5 hours a day. We have a cleaning company during the day. That's what allows me to do this, and we're debt-free. So this is my hobby. I don't go fishing and all that other crap. I try to save the world. So help me out to make the wife happy, man. In fact, if you guys did give $1 a day, and there was 47,000 of you, and you did it, and each of you gave $1, and that was every month, oh my God, yes, I could quit. I could start suing them. Another idea too that we have is, if I got, you know, some funds, we could actually contact everyone that has been ticketed and or arrested and put in jail and start sending them postcards to let them know we're here and to see if everything went all right, and if it didn't, find out their story. So we could even do more investigations and more lawsuits. Lawsuits take money. So just think about that. You know, 47,000 of you so far right now. You know, $1 a day. I mean, $1 a month on Patreon, or $5 a month Patreon, 10, 20, whatever. Just do the math in your head. Help out. This is a lot of work every single day. Thanks.